I mean, we should technically have an additional explanation, the definition of rape in the Pakistan Penal Code, which clarifies this to lay out the law as it stands.
The majority judgment still in effect assumed consent on behalf of the victim and turned the conviction into one of fornication. But in the recent past, we've seen that effectively courts are actually punishing potentially victims for coming forward and speaking out. And there isn't an environment where victims will feel that they can come forward, because now, as you've said, the courts have started questioning the victims, and they've in a sense been happening for a long time as well, where they shift the burden onto the victim, they shift the onus onto the victim. I'm Rida Hosain, and in today's case in point, we're going to talk about two very troubling judgments that have come from the superior courts of Pakistan in the recent past in cases of gender based violence. These judgments reflect how our courts view consent and how they view sexual violence. In one case, the Lahore High Court held that a husband could not be prosecuted for rape until the divorce was finalized under the Muslim Family Laws Ordinance. In another case, the Supreme Court converted a conviction of rape into fornication. The first case related to a case where the allegation was marital rape. The case title was Jameel Ahmed versus the state. And in that case, the woman had accused her husband of rape. And in the entire judgment, the focus was on whether the two parties were married. And the court eventually reached the conclusion and held that because at the time of the alleged incident, at the time the woman made the allegation of rape, the marital bond subsisted, the parties were married, so the man couldn't be prosecuted for rape. And effectively, the court linked the prosecution of rape to marriage and held that the marriage itself can, in certain cases, mean consent. And the court went so far as to quash the FIR and prevented a husband from being prosecuted for rape under the Pakistan Penal Code on the sole basis that the parties were married at the time of the alleged incident. In the second case, the Supreme Court converted a conviction of rape into fornication. And in this case, the trial court convicted the man of rape. The High Court upheld the conviction. And at the Supreme Court level, the conviction of rape was converted into fornication. And at the heart of the decision of the Supreme Court was that there was medical evidence that sexual intercourse took place. There was other evidence that sexual intercourse took place, but the court assumed that it was consensual and converted the conviction into one of fornication. In the Supreme Court judgment, there is a dissent by Justice Salahuddin Panwar, who categorically says that consent cannot be assumed on behalf of a victim. If a victim is coming to the court, if a victim is saying that she did not consent to sexual intercourse, the court cannot assume that consent. But this was a dissenting judgment. The majority judgment still, in effect, assumed consent on behalf of the victim and turned the conviction into one of fornication. To talk about both of these judgments in a bit more detail, we're joined by Sahar Bandial. Sahar is an advocate of the High Court. She has done a lot of work on gender-based violence. She was part of the legal team which was pursuing the case regarding two-finger testing and virginity testing, and eventually even the landmark judgment of Justice Aisha Malik, where they outlawed virginity examinations for the purposes of determining the virginity of a victim in cases of rape and sexual violence. And we're very happy that she has joined us today. Sahar, if I can first ask you about the judgment relating to marital rape. And this is something that comes up again and again. Given the amendment in 2006 and then in 2021, can husbands be prosecuted for rape under the law as it exists today in Pakistan?
Rida, I'll start off with first explaining that before the amendment in 2006, the definition of rape had what we call the marital rape exception, which meant that husbands could not be prosecuted for having sex with their wives without their consent. Essentially, the idea was that in a marriage, a woman provides irrevocable and persistent consent to her husband to engage in sexual activities. Now, what the Lahore High Court judgment in this case does is that it resurrects that marital rape exception and essentially says that because the marital bond was intact, there could not have been any rape because the woman is taken or presumed to have consented to the sexual activity with her husband, given the persistence of the marital bond. In 1979, the definition of rape changed. Rape was moved from the Penal Code to the Zina Ordinance, and they existed even in the 79 Pakistan Penal Code definition and also in the Zina Ordinance definition of Zina bil Jabr, the concept of the marital rape exception. What happened in 2006 is that Zina bil Jabr or rape was removed from the Zina ordinance and was re-legislated into the Pakistan Penal Code. But what is important for us to remember is that when that happened, the marital rape exception, which existed in the definition of rape, was removed. And of course, that omission by the legislature was intentional. And in effect, it provided room for prosecution of non consensual sex in a marriage. So the marital rape exception, once removed, now provides room in our law to prosecute husbands in a marriage for non consensual sex. So there is definitely room in the law for such prosecution. But what we see in this Lahore High Court judgment is that the courts are not taking account of this very intentional removal of the marital rape exception from our law. And in fact, are still working on the older paradigm or older definition of rape.
And I'm so glad you talked about the fact that this exception, the fact that it was taken out, it was intentional. The legislature did this intentionally. But this then raises the question that this marital rape exception used to exist at one time. It no longer exists. Parliament intentionally removed that exception, but you still see judges. And in this particular judgment, which is available on the Lahore High Court website, Jameel Ahmed versus the state, the entire discussion in a case of rape was about the marriage. There was little to no discussion on the allegation of rape or what the victim had said. The entire discussion in the judgment was related to whether they were married and whether the marital bond subsisted. So, do you think that Pakistan needs to legislate to include a separate offense of marital rape, or do you think that the law, as you said, there's no exception anymore, that the problem lies more in the judicial interpretation than it does in the law or the legislation itself?
Rida, you're absolutely correct. If you go through the judgment, the entire discussion seems to be on Section 7 of the Muslim Family Law Ordinance, which is the question whether or not the divorce that the man pronounced on his wife became effective or not. And the essential decision then by the High Court is that the divorce had not become effective. Therefore, the man and the woman were still married. The marital bond subsisted. And beyond that, there's no discussion as to what exactly the woman has said. The woman, at the time this incident took place, the husband had pronounced talaq upon her once. So, notwithstanding that, the court continued to insist that because the procedure for finalizing talaq had not been completed, therefore there could not be any rape in this particular case. Um, Also, one thing that I want to point out as well is the court disregarded the definition of consent that we now have under the 2021 amendment, which was the Anti Rape Act that was passed in 2021, which categorically said that consent means unequivocal voluntary agreement, therefore, implying that there has to be a positive proof of consent as opposed to a presumption of consent. In this case, the High Court is entirely working on the presumption of consent on account of the marriage of the parties. So I think that's another sort of disconnect that this judgment has with the more recent articulation of the law following the 2021 amendment. Now, moving on to your actual question, which is whether or not we need a clear exception or explanation in the definition of rape, which says that marital rape can be prosecuted or that marriage is in no way a defense to the accusation of rape. The short answer is possibly yes. I mean, we should technically have an additional explanation, the definition of rape in the Pakistan Penal Code, which clarifies this to lay out the law as it stands. But then the question is that the solution? Will that lead to a shift in judicial thinking or judicial approach? And my answer is that I don't think it will do so in the immediate run because this is not just a question of judicial mindset, it's a question of societal mindset. If you recall, you and I were part of this roundtable conversation, and one of the on sexual violence against women in Pakistan, and one of the issues that came up was that even at the stage of reporting of such an offense, there's a degree of disbelief when it comes to the commission of sexual violence in a marital relationship. And in fact, that police officers I interviewed in the course of a study on sexual violence in Pakistan, they were very categorical in their opinion that sexual violence in a marriage is very low on their priority. So there has to be work done to change the entire societal mindset from the point of the police, prosecution, medical, legal, and eventually the judiciary. So yes, the shift in law will help clarify the law, but then again, whether it's implemented or not, that's a longer journey. We see how the definition of rape has been amended in 2021. You have object rape included, you have a penetration of other body orifices, including the definition of rape. But we see cases that probably have come before you as well, where courts are continuing to prosecute object rape or penetration of other bodily orifices under Section 377 related to unnatural offenses and not rape. And we're talking, we've been like nearly 5 years since that amendment has been passed, but still it hasn't really been absorbed and is not being implemented by our courts.
So, one of the aspects which you've explained is that the court assumes consent in these cases, especially where there's a marital relationship or a domestic relationship, they assume that the parties consent. But in this judgment, we also saw other problematic narratives that the court furthered. So, first, the court said that there was a delay in filing of the FIR and therefore disbelieved the victim on the basis that there was a delay. And we have jurisprudence by our courts which says that delay is to be categorized leniently. The courts are going to look at it leniently because in our society, especially, it takes a lot of strength for a victim to come forward. There's fear of stigma, of retaliation, of very real world consequences if a victim speaks up. But we continuously see the courts using delay in filing a
Yes.
case against a victim. And then the other very problematic aspect of this judgment is marks of violence and resistance marks. So again, we repeatedly see the court saying in cases of rape that where are the marks of violence and why does the victim have no physical injuries on her body? And in this particular case, the man was actually armed. He had a weapon. And even though the man was armed and had a weapon, the court felt that the woman should have offered resistance and there should have been marks of violence on her body to show that resistance. And this takes us back to sort of last year when Justice Aisha Malik wrote a dissent. And she was the only woman on the bench. And she said that, you don't need marks of violence in cases of rape. Victims have different kinds of responses: fight,
Responses.
flight, freeze. And it's not necessary that a victim will always fight back. And in that case, the man was not armed. But in this case, even though the man had a weapon, you see the court saying, well, you should have resisted. There should be marks of violence on your body. And if they aren't, then, that actually means that you weren't subjected to rape. So, how do you think that we can confront these kind of narratives which we see the courts repeatedly affirming through their judgments? And we have a male dominated judiciary. You have two women on the Supreme Court. One woman on the Supreme Court has already said that this is completely against science, it's completely against basic facts, and even victims who've actually been through it have disputed this narrative. But how do we confront it when you see the courts repeatedly troubling and including these troubling narratives in their judgments?
Rida, yes, the Supreme Court, just Aisha Malik in the Supreme Court decision from last year, from 2024, actually clarified that there's no one typical response of a rape victim. And in fact, marks of violence are not necessary in order to indicate the absence of consent. And in fact, even the 2021 amendment clarifies that. The explanation to the definition of rape clarifies that marks of physical resistance are not required in any way to prove that there was absence of consent. So the law is clear, right? The law, even the statute itself is clear. But again, we are confronting judicial mindset of a very male dominated judiciary. And I think it the in the end it comes to the question of raising these issues time and again, offering an alternate narrative, and of course engaging in persistent trainings and reinforcing this particular point, because I think it'll take a very, very long time for that shift to occur. because anything which is slightly deviant from what is presumed to be a typical moral woman's response, that they will not accept. They are continuing to work on, with a stereotypical idea of how a woman should react in such a situation. And I think the only way one can counter it with is with a different narrative, keep challenging the kind of opinions that come up, and of course, engaging in more effective training across the judicial system, and again the prosecutorial system and the police system.
And Sahar, you recently wrote a piece which was about the second judgment, Hassan Ahmed versus the state, where the court converted the conviction of rape into fornication. And you said that this is a relic of the Hudud ordinances, and even pointed to a provision of the amendment in 2006, which expressly said that when there is a case for rape, you can't convert that into fornication. That was expressly included in the law. And yet again, this is, I think, the third or fourth judgment in the recent past where the courts have actually converted a rape case into a fornication case. And what they're effectively saying to victims of rape is that if you come to the court, if you approach the legal system, actually what might happen is you might end up being prosecuted for fornication. And in the judgment that you even wrote about, in that case, the court even says in one judgment that, actually, since the woman wasn't included in the FIR at the initial stage, right now we're not going to do anything to the victim. But, in the future, they leave the space open for a case to be brought against a victim for fornication if she comes
Mhm.
to the court. And so now victims will even have a threat of being facing criminal liability,
Absolutely.
possible imprisonment if they get convicted for fornication, if they come forward and report rape. And you even wrote this in your piece that this sort of takes us back to the Hudud ordinances, to Ziaul Haq era law, where women, when if they were pregnated, that would be that assumed that it was adultery, or that women used to spend months and years in prison only to be later acquitted by the higher courts, and they used to take even an allegation of rape as adultery or fornication. So it seems that our legal system, rather than progressing forward despite amendments to the law, is taking us all the way back to history and to very dangerous and troubling times for women who have been through that already in Pakistan. We seem to be going back to that.
Yes, yes, absolutely. You see, Rida, the problem with the Hudud ordinances was that an allegation of rape, zina bil jabr, subject to had punishment, could only be proved either upon the confession of the accused or upon the provision of the testimony of four male witnesses of good standing and character. When a woman complained of zina bil jabr and was unable to prove the allegation through the required evidential standard, she could be charged of adultery, zina. Her complaint would be treated as a confession that she has engaged in illicit sexual intercourse. And that is exactly what we saw was happening. And this is one of the reasons why the 2006 Women Protection Act was promulgated. If you look through the statement of objects and purposes of that law, one of the primary reasons for enacting it was to address this absurdity of the law that had emerged under the Zina ordinance. And now, so many years down the line, 20 years, 19, 20 years since the passage of the 2006 amendment, we see Supreme Court judgments which are going back to that practice, where a woman cannot prove rape through at the required evidential standard, which is obviously different now because rape has been removed from the Zina ordinance. She can be subject to an allegation of adultery and becoming accused in a trial. So the law inverts, it converts a victim into an accused, potentially with the prospect of her, as you said, facing criminal punishment. So, this is how the relics of the Zina ordinance are now being resurrected in clear violation of to the 2006 Women Protection Act, which provided number one, that no case or complaint of rape will in any situation be converted into a complaint of adultery or fornication. And second, what the 2006 amendment did was it prescribed a particular process or procedure through which a complaint of fornication under section 496B of the Pakistan Penal Code could be brought. And that was only upon filing of a complaint before a court of law and after the court of law examined two eyewitnesses and the complainant. Now, the effect of the Supreme Court judgments is number one, to, as you said, convert rape conviction to one of fornication in violation of the 2006 Act, and two, to themselves become a complainant against the victim. And as you said, the court said, oh, right now the complaint hasn't come, but if a complaint does come and evidence is brought against her, yes, she can be convicted of 496B. So, although not directly becoming complainant, giving room for that prosecution to take place.
And I was at this conference 2 years ago where Justice Aisha Malik was speaking, and there's a video of that also publicly available, where she said that, she wants to see our justice system be changed, or one where we look at things from the victim's perspective, because the
Mm-hmm.
victim is coming to court, and we have to change the way we think at the police level, the prosecution level, and at the court level. At all levels, we must look at things from the victim's perspective.
Most important is what everyone has been saying this since morning, the victim's perspective. This is very important. It all follows in with the gender perspective, the language, the victim's perspective. And unfortunately, our system, particularly our criminal jurisprudence, is geared and fixated on the accused. We think about the accused's right, but we don't think about the victim's right. But when it comes to women and gender-based violence and issues pertaining to women, we must think of the victim. We must think of the difficult circumstances in which she has come to the court, what she wants from the court, what she is trying to tell the court. And I often tell my children that there's a difference between hearing someone and listening to someone. So we really have to listen. We don't have to hear them, we have to listen to what they're saying so that we understand what they're saying.
But in the recent past, we've just seen that effectively courts are actually punishing potentially victims for coming forward and speaking out. And there isn't an environment where victims will feel that they can come forward, because now, as you've said, the courts have started questioning the victims, and they've, in a sense, been happening for a long time as well, where they shift the burden onto the victim, they shift the onus onto the victim, that you tell us, you say that you weren't consenting, but actually we think that you were. Even if you don't say there was consent, we're going to assume consent on your behalf.
Exactly,
And a
exactly.
victim can say, and in this case, the one which you even wrote about, the victim said she did not consent, and the trial court agreed with her, the high court agreed with her, the Supreme Court said, actually, no, you were consenting. And so we're going to change the conviction at the highest appellate forum altogether, a forum that hasn't heard the evidence, that is just looking at it at the final stage, is changing the conviction. And then again, the marks of violence, shifting the onus onto the victim, that you should have done more. You were potentially subjected to an unlawful act, but you should have done more. Why did you not fight back? So
And
again,
and Rida, even if the case of fornication is not brought against the victim in these particular cases, but what the Supreme Court decision is doing is that it is labeling that victim as an adulteress. Given our society and given the sort of culture we all live in, that label itself is punishment for that victim. It's very difficult, and you said that initially at the beginning of our conversation. It's so difficult for women to step up and come forward and file such complaints. And these sort of decisions are discouraging them even further. At the highest court of our country, these decisions are reinforcing the belief that if a woman becomes a victim of sexual violence, it's better that she keeps quiet and carries on with her life rather than pursuing justice. And the courts are effectively violating the woman's right to access to justice, her right to equality, her right to be dealt in accordance with law, her right to life, her right to dignity, etc. So these decisions are, in fact, a violation of a Pakistani woman's constitutional rights as guaranteed in the Constitution of Pakistan.
And there is a possibility that if the court feels that there isn't enough evidence before the court, or they don't feel that it's been proved beyond reasonable doubt, for them to dismiss the rape conviction and for them to say that we feel as judges that it hasn't been proved, so we dismiss it. But what's
Yes,
even more troubling is that they go one step forward. They don't just dismiss it, they say actually we convert it and we leave the room open for the even the victim or the woman to be proceeded against, because there can be cases where the court feels that there isn't enough evidence
of
before them
course.
to convict. But to then say that, okay, simply because of the fact of sexual intercourse is proved, we're actually just going to convert this into conviction for fornication and punish the victim. And as you very rightly said, that label, that going through that entire process, that itself is punishment enough for a woman or a victim. And this is one case, but the message that this sends is in all cases for all
Mhm.
potential victims who may be looking at how the courts are treating this case, and it may discourage them then from speaking up because they feel that they may themselves be end up being punished, or as we've talked about,
Absolutely.
subject to criminal proceedings. Sahar, we've both advocated in the past for increasing female representation in the judiciary, so that and it's also been written about by a lot of academics, that female judges look at things from a different perspective. Not always necessarily, but they do bring a different perspective to the bench, a different voice to the bench. And women represent half of your population, and that should be reflected in the judicial system itself. How do you think that we can advocate for that more strongly in terms of increasing the representation of women in the judiciary? And do you think that that will make a difference in cases of gender-based violence? Because right now you have a predominantly male-dominated, male-centric judiciary judging cases of gender-based violence and judging cases of sexual violence.
I think more women on the bench and women sort of adjudicating upon gender-based violence cases or family law cases, maintenance cases, custody cases, etc., will definitely bring a more nuanced perspective, a female perspective to decision making, for sure. And we see that in the Muhammad Imran case, as you mentioned, that the dissent in that case was by a female judge who categorically stated that presuming consent in gender based violence cases is a violation of a woman's right to dignity, privacy, etc. Language that come from a male judge. It came from a female judge. So there's a case to be made for more female representation for sure. How we do it, I mean, there are different debates, different approaches to it. One, of course, is like have a quota system, specify the number of women that should exist in the judiciary. I'm not sure I entirely agree with that because I do believe that elevations should be in terms of merit, etc. But even if the elevations are based on merit, one of the aspects that the Judicial Commission must take account of is to make the judiciary more diverse. And if that's one of the objectives of the JCP, of the government, of the state, then of course more women will be considered. We see, and we've seen this in the past, that very few women are even make it to the list that's put before the JCP. It's hardly any women that are put on the list. And if the list is made with the perspective of there being more diversity, more gender representation, then we may have more women being considered. And I think that's the way forward.
Absolutely, I agree with you. And I think that when we see Justice Aisha Malik's even general jurisprudence on other factors, whether it's Muhammad Imran case where she wrote her dissent, or the case where she in review held that the workplace harassment law doesn't
Yes.
just apply to cases of a sexual nature, but also includes gender-based discrimination in maintenance cases, in cases where married women have been denied their right because they've been tied to a male partner or a
Yes.
father or a male relative. She's talked about the right of women to financial autonomy. So we do see the difference that it has made ever since that she has been on the bench. We've seen that real world consequence. So when people say, what difference does it make? We can now say that, it does make a difference, even practically, if you look at how much of a shift there has been in the jurisprudence that was coming from the
Absolutely.
Supreme Court. Even a lot of progressive judgments by male judges, Justice Mansoor Ali Shah, Justice Babar Sittar, we've seen given progressive judgments in cases of gender gender-based violence. But then that brings me to the last question, which is that we have conflicting judgments in our courts, and I think that that's a huge problem. So you have judgments where the courts have held, even by majority, that marks of violence are not necessary, but then you have judgments where courts have held that marks of violence, if they're not there, that disproves rape. Then you have judgments which say delay is to be looked at leniently, and that courts will not sort of disprove an allegation of rape simply on the basis of a delay. But then again, you have judgments where courts are saying that if there was a delay, that means that the victim is to be disbelieved, or that her story is not as convincing. And then you have judgments like one by Justice Babar Sitar, where he's talked about the sole testimony of a rape victim being
Yes.
enough in a case of rape to
Yes.
convict. That
Yes.
if a rape victim's story or her evidence is confidence inspiring, that sole testimony is enough for a conviction. And then there are other judgments which conflict with that. So how do we sort of go forward from this? Because it creates a very confusing environment, even generally in terms of our jurisprudence, where if somebody even asks us that what is the law on these particular points, it can actually go both ways. And that also leaves the room to the discretion of a particular judge, that how a particular
Absolutely.
judge takes it, rather than what is the law in Pakistan, because there's no real clarity.
Absolutely. I absolutely agree with you, Rida. And it gets confusing for us as practitioners. There's more discretion with the bench to decide one way or the other, depending on what is most convincing to them. I think one way forward, of course, is for there to be statutory clarification on this. Because sometimes you have conflicting decisions within the Supreme Court also, and then conflicting decisions between the provincial high courts as well. And I think eventually either there is statutory clarification, which, as it's been done now in the 2021 Act regarding the irrelevance of marks of violence. Such could be done regarding delay as well. But eventually, it will come down to the question of how this sinks in to the judicial mindset, and whether or not they over time adopt this changed thinking that the statute is now indicating as a right way forward or not. And then, of course, we lean on training the sector. And if you remember in the last workshop, that the sort of roundtable you and I attended, it ended with the note that there should be training not just at the district judiciary level, but up to the superior judiciary level as well, if we are to have a more coherent, consistent understanding of the law. So, potentially, without any offense to anyone, potentially that's one way forward. The statute changes, and the changed meaning of the law is then reinforced through training, through conversations, through the judicial academies, etc. That's one way forward that I can think of.
Thank you so much, Sahar, for your time. I think that one of the most important things that Sahar has also talked about is statutory clarifications, because as she's very rightly said, that judicial interpretations and the way that judges understand cases of gender-based violence and trainings are important, but even statutory clarifications in terms of clarifying what the law means can also take us a long way. Thank you again, Sahar, for your time, and hopefully the
Thank you,
next time
Rida.
we sit down
Thank
to
you.
discuss a judgment, it'll be a judgment which is more progressive than this one.